Good afternoon, everyone. Welcome back after the lunch break. I trust you're all refreshed and ready for the riveting next session in the afternoon, or the graveyard shift as it's called. And I'll try and keep it as interesting as possible, while as interesting as these things go. We'll proceed with what is called the third-party procedure, and you'll find reference to that in Rule 50 of the rules. Let me just find my electronic version, and we can page to page to Rule 50. Which is again one of those issues or procedures that apply in the middle of, you'll recall the little, the steps I wrote down of exchange of pleadings and how parties then exchange pleadings up to the end. And Rule 50 is what is called the third party procedure. So it's where a party wishes to seek a contribution or an indemnification from a third party, or a question or an issue is substantially the same as a question or issue that will arise between a party in the suit and a third party. So, for instance, I enter into a contract with company X to fix my aeroplane's engine. Company X, in turn, for part of their mandate, needs to contract a subcontracting company which specializes in aviation fuel injectors, let's say. So they, in turn, have a contract with the subcontractor, and therein is an indemnification for that part of the scope of works. Now, I obviously sue the person I contracted with, who was going to fix my aircraft's engine, and in that process they say, well, wait a minute, maybe so that we're liable to you, but at least we're entitled to an indemnification or a contribution towards this claim from the subcontractor. So we're going to issue a third-party notice so that they can come and join these proceedings, so that they can answer for this part of your claim that relates to the aviation fuel injector, which is the specialized part that they did. So this is where you follow, from a very basic point of view, this is what a third-party procedure entails. So Rule 50 says, where in an action a party claims as against any other person not a party to the action, that's a third party, that is entitled, that party is entitled in respect of any relief claimed against him or her to a contribution or an indemnification from the third party. So it's where a party against whom something is claimed is entitled to an indemnification or a contribution by a third party who's not a party, and it's not necessary that a nexus must exist between the plaintiff and the third party. It's the defendant now who seeks a contribution or an indemnification. Or that any question or issue in the action is substantially the same as a question or an issue which has arisen between that party and the third party, and the question or issue should be properly determined not only as between the parties to the action, but also as between those parties and the third party, or between any of them. So again, similar issue that will arise, principal issue. Remember I spoke to you earlier about a principle, same principle applying to other parties. So where it relates to an issue which will also be determined between that party and a third party, it can conveniently through the third party procedure just be decided in one. And that then you may issue what is called a third party notice. That's on Form 16. And the notice must be served by the deputy sheriff. So you're basically calling a party to join the party, so to speak. All right, so the third party notice must be served before close of pleadings. I think that's in the next slide. Let's see. Yeah, the third party notice must contain the nature and grounds of the claim of the party issuing the notice. It must set out the question or issue to be determined and the relief or the remedy claimed. It must be served before close of pleadings. Where pleadings have already closed, you need to obtain leave from the court in order to file a third-party procedure, pleading or notice. You can have a look at Mercantile Bank Limited versus Carlisle and another, 2002, Volume 4, South African Law Reports, page 886, Witwatersrand Local Division. And that deals with third-party procedure and the basic principles relating to that procedure. Important to know and understand the procedure. A mere reading of Rule 50 would give you a good guideline as to. All right, that then takes care of pleadings and procedures that, in that example, absolutely, because what would happen is it's the defendant who wants the indemnification or the contribution from that third party, because it says, yes, I might be liable to you, but if I am, then this person is just as liable in these circumstances. It has nothing to do with the third, in that instance, yes. And of course, it's a third party procedure may become relevant where a plaintiff, where further action arises between the plaintiff and another party, which is substantially the same issue as the one that will be determined here. Say, for instance, that contract then has a different twist to it, or some permutation, then that's how that would happen. Of course, in this example I gave you, there's also the possibility that the third-party procedure is not only because you wanted indemnification, but because the defendant might say, well, it may be so that I'm liable to you, but if I am, then this third person is liable to me. It will be determining this will determine that. So I want them to be joined now already so that you can determine both of these together, and then at the end of the day, I'll pay you and they'll pay me, because in that scenario, there's no contractual or other nexus between the plaintiff and the subcontractor. So you sort of saying that there is no connection, but because I'm as defendant, well, if I'm liable, then they'll be liable to me. So let's just decide this issue all in one. Third-party procedure is not something that's used daily. It's a specialized procedure in instances, and where it works very well. But it's not something. It's not your run-of-the-mill type of application that is made to the court. Well, no, not necessarily, because, well, causation with one of the parties at least. But in certain instances, for instance, where we said that it will be the same question or issue to be determined. Sorry, let's just go back one. A question or issue which is substantially the same as a question or issue which will arise between the party and the third party. In that instance, causation really will have nothing to do with it. That's just really a matter of convenience. It's to say this. It's the second example of the aviation issue that I raised. So the defendant is saying, well, if I'm liable to the plaintiff, then the subcontractor will be liable to me, because what will determine this liability is the same as what will determine this liability. So we may as well decide the two together. So you, third party, come to the party now, and the court will decide this, and then if I'm liable to them, I pay them and you pay me. But their causation doesn't really play a role. It's just whether a cause of action exists or a legal issue arises between the parties. The plea. Good. So Rule 46, I think as a point of departure, let's turn to Rule 46. It's an important rule to know. I think generally the importance of the plea is often overlooked, and parties often draft a plea without the necessary precision, often under time pressure or for some other reason, and it leads to issues later. So it says you must obviously deliver your plea. The timing for delivery of the plea will be set out in the case plan. So previously there was a time period connected to the delivery of a plea in the rules, but that has changed, and now parties are obliged to deliver their plea as agreed to between the parties and sanctioned by the judge in terms of a case plan order. But we'll deal with case planning tomorrow. Every plea must deal with each and every allegation made by the plaintiff in his or her particulars of claim. So remember, where you fail to deal with a specific allegation or paragraph in the plea, it's deemed to be admitted. You must clearly state which allegations by the plaintiff are admitted. So you must say, if you admit something, you must clearly state that. And clearly and concisely state all material facts on which the defendant relies in defense or answer to the particulars of claim. So there's the subparagraph 3. Every allegation of fact in the particulars of claim which is not stated in the plea as denied or admitted is regarded as having been admitted, and if an explanation or qualification of an admission or denial is necessary, it must be stated in the plea. Okay, so what needs to be done in a plea, and you have an example of the plea in your files, and I will just briefly deal with an example of a plea. So here you have your rule, reference to Rule 46, defendant's plea in the High Court case number. This is now an older paper file, so it hasn't got that long e-justice number yet. And then you'll say defendant's plea. The defendants, here it's 2 defendants, refer to the plaintiff's particulars of claim and plead thereto as follows. Then you'll see add paragraphs 1, 2, 3, and 4. The contents thereof are admitted. This is now relates to citation of parties, so that's not denied in this plea, so the contents are admitted. Then paragraphs 5 and 6, safe to admit that the parties during or about October 2011 and at Amsterdam entered into a written agreement. The remainder of the allegations are denied as if specifically traversed and thereafter denied, and the plaintiffs are put to the proof thereof. So you want to admit a portion thereof, but the rest you want to deny, then you say so. You say safe to admit this, all the other allegations are denied as if specifically traversed and thereafter denied, and the plaintiffs are put to the proof thereof. I just want to, so then for instance here, add paragraph 8, there's a denial and it's necessary to explain the denial. Then you'd say, each and every allegation contained therein is denied as if specifically traversed and thereafter denied, and the plaintiffs are put to the proof thereof. In amplification of the aforesaid denial and without derogating from the generality thereof, the defendant pleads as follows, and then the defendant pleads why he or she denies this particular paragraph. Now, there are certain paragraphs that will simply be denied because it would say perhaps the particulars of claims in the premises, the defendant is indebted to the plaintiff in the amount of 1 million Namibian dollars. That's just denied, and it follows from the body of the plea why it's obviously denied because you've set out why you're not liable. So certain instances it is in order to actually just deny. Please remember that where an admission was made in a plea, that cannot be withdrawn by an amendment without leave from court. So a party will have to apply to court for relief relating to the withdrawal of an admission. So it's serious business. If you deliver a plea or a plea is delivered wherein admissions are made, that cannot very easily be withdrawn. Of course, you can, by way of a simple amendment, you can withdraw a denial and replace it with an amendment or an admission, and I'm fairly certain your opponent will not be too worried about that because that would be in their favor. But essentially, please remember that you cannot easily and without leave from the court withdraw an admission in a plea. A no-knowledge plea is a difficult plea. A no-knowledge plea means that you have no knowledge of it, and therefore you cannot admit or deny same, and you put the plaintiff to the proof thereof. Once the plaintiff has presented evidence proving that fact, you're bound by it because you've pleaded no knowledge. If you cannot simply test something just under cross-examination just for the sake of testing it. So of course you can test you can test whether what he or she is saying under what they said under examination in chief is indeed correct, and of course you can test that. But you can't put something to the contrary to them, because you haven't pleaded something. You've pleaded that you have no knowledge of this. So you want them to come and prove it, but once they've proven it, you can't lead evidence to the contrary. Then you'll have to amend your plea. So of course you can test that version under cross-examination, but you can't present evidence to prove the contrary because you've said you don't have knowledge. If knowledge comes to light later on during the proceedings, and you wish to amend your plea, you can do so. You can say, now, and it's easily explainable, to say, well, I mean, in the meantime, this has come to my knowledge, and I now have knowledge of this, while at the time that I actually filed the plea, I didn't have knowledge. So that you can do. That's not an admission. And no knowledge is simply saying, I don't know now. That may change in future. Not unless you amend your plea then. So you can present contrary evidence, but then you need to amend your plea. You can't present contrary evidence while relying on a plea of no knowledge, you see. So there you need to amend your pleading to set out what it is that you now want to present.
Thank you.
Well, if you have no knowledge, then you're already being told what the allegation is in the particulars of claim, and you need to plead thereto. So it would, for instance, say, I, as the plaintiff, am the duly appointed liquidator of this company in liquidation. Then you as a defendant might not know whether I'm duly appointed as plaintiff. So you will say that I don't have any knowledge. If during the course of proceedings someone whispers in your ear and says, look, I mean, maybe you should just ask the master, because I've heard that there was no appointment ever, and you investigate and you realize that that's your client investigates, a party investigates and realizes that there's information to prove the contrary, that will certainly lead to a plea, and that will amendment of the plea. And the stage of proceedings will obviously dictate whether the amendment will be allowed or not, because it's a very important consideration, and we'll deal with amendment applications going forward. So essentially, I don't think it's necessarily an issue of pleading no knowledge, because you'll take a big risk if you have information to the contrary and you don't plead, and that's not pleaded, and you plead no knowledge. In fact, it's probably unethical to do that. You can't plead your client has no knowledge if they have knowledge. I've already said time period for filing of the plea. That will be determined by means of the case plan. If you don't deliver the plea in the time period provided for in the case plan, you will be ipso facto barred. So it means that you cannot deliver the plea. You can physically do it, I suppose. I'm not sure whether e-justice will throw it out as being irregular. I don't know whether e-justice is that sophisticated, but you may physically be able to do it, but legally speaking it would be a nothing, because you are barred. So you can only do that once you then apply for condonation for your non-compliance and for upliftment of the bar, which is an interlocutory proceeding, and which we'll deal with tomorrow when we deal with interlocutory proceedings. Then remember, in the plea you are required to admit or to deny or to confess and avoid. So those are the only things that you can do in a plea. When you deny, you need to often explain and set out the facts on which your denial is based. Admission is easy, contents are admitted. I notice sometimes there's this, the contents thereof are noted. I don't know what that means. In law it means nothing. It's a nothing. You can't note contents in a plea. It's like saying nothing. So you can regard it as admitted. Okay. So clearly and concisely set out all the material facts relied upon. So for instance, as I said, there's an allegation that an agreement was entered into, and you want to say, well, no, the agreement wasn't entered into because on that specific day I was under the influence of some narcotics or whatever it is that whatever permutation of the plea there is. I wasn't compos mentis because I was, I don't know what, so that may be your plea. Or you may say, well, the person who entered into the agreement didn't have the mandate or whatever it is. But you don't need to say, because on that day he woke up in the morning and then he took a handful of medication and he didn't know that the medication was going to incapacitate him for the next 4 hours, and then he drove there. And you don't need to say all of that. You just need to say because the party who entered into the agreement was incapacitated, or because the agreement is contra bonis mores, or because whatever it is that you rely on for your plea, material facts. So not the whole story, material facts. Again, clearly, concisely, paragraph by paragraph, numbered consecutively. That's how you would be drafting a plea. Any allegation not dealt with in the plea will be deemed to be admitted. I've said that a number of times. And then special pleas. Now, right at the outset, I should point out that it's very important for you to keep in mind that a special plea is raised right at the outset, but a special plea, I would never advise a party not to plead over on the merits, simply because if the special plea, you have one chance to file a plea. And if the special plea doesn't succeed, then there's nothing on the merits. Everything on the merits is deemed to be admitted. Now, there are a number of special pleas that you can raise. Some of them may extinguish the matter. Some of them are merely dilatory pleas. Dilatory pleas would be pleas of non-joinder, because the court won't non-suit a party for having not joined a necessary party. The court will merely say, litigant, go back and join this party to these proceedings, and then I'll hear you. Similar with arbitration clauses. So if there is an agreement and the agreement says that the parties will submit to arbitration, that means that a special plea of arbitration is a dilatory plea, and it doesn't oust the jurisdiction of the High Court. Please remember that arbitration clauses never ousts the jurisdiction of the High Court, so the High Court will still have jurisdiction. A defendant in a suit where there's a contract which contains an arbitration clause has one of two choices. He or she can apply in terms of the Arbitration Act. I think it's Section 3, if I recall correctly. I don't have it with me at the moment. But Section 3 or Section 5 of the Arbitration Act. You can apply for the matter to be referred to arbitration in terms of the agreement. Alternatively, you can raise a special plea. So these are the options available to you. And that will then be a dilatory plea. So it won't be the end of the action. It will merely mean that the matter will then be stayed until the arbitration is finalized, which is where the parties agreed to settle their disputes. Then you have special pleas that has the potential or have the potential of extinguishing the matter altogether. That would be, for instance, a plea of misjoinder. If a plea of misjoinder against a particular party succeeds, or misjoinder of a particular party succeeds, then that party is off the hook, so to speak. Similarly, if a special plea of prescription is successful, that means that that part of the claim for which the special plea has arisen will have been extinguished. So those are, generally speaking, your types of special pleas. Please remember that a special plea of prescription can never be raised by the court mero motu. It's not, even if the presiding judge realizes that this matter must have become prescribed, he or she may not raise that plea mero motu. It must be raised by the party against whom that plea is being pursued, or that claim is being pursued, the prescribed claim. So the court may not raise an issue of prescription. So be mindful and conversant of the provisions of the Prescription Act. Certain dates prescribe after 30 years, certain dates prescribe after 10 years, certain dates prescribe after 3 years. So it depends on the type of date, whether it's a mortgage bond, whether it's a tax to the government, whether it's just a civil claim. What are claims and what are dates? Wide interpretation. Our Judge President has given some delivered a judgment in terms whereof certain of these issues and the term a debt has been settled, discussed and settled. For instance, specific performance in terms of a contract is also a debt, for which it would also mean that the prescription period is 3 years. Court should be turning a blind eye if it's not raised on the papers. The court cannot raise prescription mero moto. Well, you can introduce the special plea at a later stage by way of an amendment, but that'll be with, obviously, I can imagine that such a notice of amendment, if it comes at a late stage of the proceedings, will be objected to, and that it will be subject to leave from the court. If the court grants relief for you to introduce that special plea, then it will be argued, and of course there will be a cost implication for the party who didn't realize right at the beginning that they should have brought that special plea along, right from the outset. You do both. So you always plead over on the merits. So what you do is you raise your special plea, and then you proceed to plead over on the merits for the remainder, because there's a chance that the court may find that the claim hasn't prescribed, and then you haven't pleaded over on the merits. So you do it when you file your plea simultaneously with your plea on the merits. So those are the special pleas that you would find. And you have an example of what a plea looks like in the file that was provided to you. So that would generally guide you in how to draft that. I'm not going to give you a drafting lesson. You're not here to learn how to draft pleas. You just need to know what's required in a plea. Of course, please remember, before we get to a counterclaim, just as much as exceptions are applicable to particulars of claim, they are similarly applicable to pleas. So when a party in a plea relies on something which in law doesn't disclose a defense, or there's an ambiguity, or it's vague and embarrassing, then the other litigant would have the same right of exception as a defendant would against the particulars of claim. So be mindful of the fact that an exception can be raised against a plea. All right, that takes care of the plea. Any questions regarding the plea? Other questions? Okay, good. Then we get to the counterclaim, which is Rule 48. It's filed simultaneously with the plea. So in the case plan, we'll say the defendant will file its plea and plea and, if any, a counterclaim by a certain date, and the party must then file his counterclaim together with his plea. It's not an absolute bar if the counterclaim is not filed with the plea. You can, with leave from the court, again by way of an interlocutory application, seek leave from the court to file a counterclaim after you've actually filed your plea. So that will be on special circumstances set out in an application of that kind. In a counterclaim, the parties are referred to as in convention, which means the plaintiff remains the plaintiff and the defendant remains the defendant. It's just that the defendant now claims from the plaintiff in the counterclaim. So you don't change the party's citation in a counterclaim. And then the same rules that apply for particulars of claim, how you should plead in a particular, how you set out your material facts, what you need to set out therein. You may actually avoid the citation of the parties by saying the parties are cited herein as in convention, because it's the same parties. So the same rules apply. Also Rule 45 as to what must be in the particulars of claim, same in the counterclaim. And then, of course, a counterclaim, a party need not bring a counterclaim. So a party might actually say, well, I'm not going to apply for a counterclaim. I'm going to bring a separate action. There's nothing prohibiting a party from doing that instead of bringing a counterclaim. There may be procedural or tactical reasons why a litigant decides not to bring a counterclaim, but to bring a separate claim against the party for whatever claim the defendant has. So it's not a use it or lose it type of thing. It's if you decide not to proceed with a counterclaim, it doesn't mean that your claim now goes away. You can always proceed in a separate action. It may just be that it may be needed to be consolidate it later, or you may find yourself at the wrong end of a cost order if you abuse the rule by not making use of something which is there and then proceeding in a different fashion and abusing the court process in the process. All right, then replication. Now replication, the same principles really apply to replication, rejoinder, surrejoinder. Replication is dealt with in Rule 47. Now you won't find reference to rejoinder and surrejoinder in the rules. The rules merely speak of such further pleadings as the parties may agree on or may deliver. So Rule 47 deals with the replication. Time period, the thing is that often, well, at least nowadays, more often than not, the replication time periods are dealt with in the case plan. But what you won't find at all, well, I've certainly never seen that in a case plan, is that the parties deal with a rejoinder and a surrejoinder. But that doesn't mean that the parties don't have that right. It's just that it will probably entail the parties calling a status hearing before the managing judge and saying, look, the replication has now been delivered. We foresee the need to file a rejoinder and then a surrejoinder, so we need to agree on further timelines for doing that. So even if it's not in the rules and not in the case plan, it doesn't mean that your right to file these pleadings suddenly goes away. A joinder of issues means that you simply say, well, I don't agree with you. I say this, you say that, and that's the end of it. Replication is necessary where you want to admit allegations contained in the plea, or where you want to, more importantly, confess and avoid allegations contained in the plea. So you would say, yes, it is correct that the claim arose more than 3 years ago. However, you, Mr. Defendant, was out of the country for the last 5 years, as a result of which prescription was stayed, and therefore the matter has not become prescribed. So that's something you'd raise in a replication, for instance. Estoppel, to say that the true state of affairs may be this, but you've acted in a certain way to make me believe that this is the true state of affairs. I've acted to my detriment, and you are therefore stopped from relying on the true state of affairs. That's something you'd raise by replication. So, for instance, if you want to rely against the company on the Turquoise rule, which says that you don't need to know all the internal workings of a company for purposes of authority, and then there's ostensible authority because you worked with someone who represented to you that he or she is duly authorized, then you would deal with that. If authority becomes an issue in the plea, you deal with that by way of a replication. So remember, in a replication, you're opening up the pleadings again. So remember that when you file your replication, you need to join issue with the paragraphs of the plea not being dealt with in the replication, and you don't need to again deal with all the allegations in the plea. So you'll deal with those paragraphs of the plea that relate to what you want to say in your replication, and then you will join issue with all the remaining paragraphs. So what it looks like in practice is a replication. The plaintiff replicates as follows to the defendant's plea. Then it will start off by saying, save as qualified below, the first defendant persists with the allegations as set out in its particulars of claim and joins issue with each and every allegation that is in conflict or inconsistent therewith. So you start off by saying, I'm not opening up everything now and admitting what's in your plea. I stand by what I said. I just want to qualify what's in your plea. And then here, for instance, was one where prescription. The first defendant avers that prescription only notionally starts running in these events and sets down, and then further pleads that even if prescription did start running, which is denied, then in terms of the provisions of Section 13(1) of the Prescription Act, the period of prescription has in any event been delayed and not yet been completed, wherefore the plaintiff persists with its claim against the defendant. So this is what a replication. So the plea is obviously long. You only wanted to deal with the issue of prescription in the replication. So you deal with that, you join issue with all the remaining allegations and persist with your particulars of claim. So you're basically just clarifying. You may want to admit, confess and avoid. So yes, claim of cause of action may have arisen then, but its prescription was stayed or delayed because of this, that or the other. Or as I said, estoppel or any of those issues that you will obviously normally raise by way of replication. All right, then, so rejoinder and surrejoinder. Rejoinder and surrejoinder, exactly the same. So I may have raised an issue there to say, well, you were out of the country during that time, then you might come back in a rejoinder and say, I was out of the country, but only for 3 months. The remainder of the time the plaintiff was, or the defendant was in fact here, and therefore prescription was not stayed. So you may just want to qualify that. Deal with that and join issue with the remaining. So it's exactly the same. Join issue, stand by your pleading, and proceed. And then it may be that after that a party wants to again deal with something that came out of the rejoinder, and then again files only dealing with that aspect. So it's not you don't need to deal with everything. You're only dealing with that particular aspect of the previous pleading that needs dealing with. All right, so that is pleadings up to surrejoinder, and after that you'll have close of pleadings. Any questions on the plea, replication, rejoinder, surrejoinder before we proceed? Okay, you have examples of the plea, you have examples of the particulars of claim, so I trust that you can look at those. If you have questions when looking through those, even tomorrow, please feel free to ask me. I'm here until Wednesday, and of course over the weekend if you're studying, I'd be glad to answer whatever questions you have. I'm not sure what the rationale is behind the court not being allowed to raise it mero moto, but I can tell you that the court's not allowed. So it's not for the court to think up defenses. And prescription is one of those issues that you cannot raise mero moto. It's just the way it is. I don't think that you believe me, but it's the way it is. Well, I mean, you might be right. I honestly don't know the rationale behind the rule, but that is the rule. What I can do this evening is I can have a look at case law and how it developed and why it developed the way it has, look at the act, and then I can tell you what I think, but that'll just be my interpretation. I can only tell you what the rule is, just like I can't tell you why they've decided on this number of pleadings, but that's the hand that we've been dealt, so that's what we need to deal with. Oh, I don't, I'll have to just have a look. You can actually on Safely or on eJustice just Google and you'll see date prescription, Damasep, and you should be able to find it. I don't remember the name or the citation off the top of my head now. All right, so do you want to take a comfort break and then we proceed with, all right, so let's take a comfort break and we'll be back at 3:05.